So this is, in this session we'll take week 5, and these are other torts, so sort of miscellaneous areas of torts. We have discussed the law of negligence in detail. So now we're going to be looking at some other business-related torts, which are also significant to learn about as well. We're going to divide this discussion into torts that relate to the use of property and those torts that arise out of business operations. So because there are so many torts that relate to the use of land, and land is very important in business obviously, there has been a specific body of law known as occupier's liability, which is important for us to appreciate, which is developed out of the general principles of negligence. So the occupier is the person who has the legal right to occupy the premises. It may be the person who owns the property, but it may be the person who's renting that property because they have a degree of control over that property. So occupier's liability will describe that liability where the occupiers have to anybody that enters onto that property. So for example, the occupier here is you or IT, and you've entered into their property and coming into the classroom, for example. Now, important about occupier's liability at common law, there's also statute law that informs this discussion as well, is the class of visitor that comes onto the property. When you come onto the property as a student to the UIT campus, you're a contractual entrant actually, because you have a paid right to enter the premises. An invitee and licensee are individuals that come onto the property to benefit the occupier, or that don't have a particular any objection. There's no objection to their presence by the occupier. The last category of visitor, we might say visitor, but somebody whose presence is objected to by the occupier is a trespasser, somebody who's not invited and whose presence is in fact objected to by the occupier. Now, what you need to appreciate about these different classes of visitor is the standard of care that's owed to each. What you'll appreciate is the standard of care is highest in relation to the contractual entrant and lowest in relation to the trespasser. Just because the person is a trespasser doesn't necessarily mean that they have no standard of care, there's no standard of care owed to them. The occupier is said to at least owe them the common duties of common humanity, as it's known. Now, there's also occupier's liability legislation, which exists in all provinces, which provides what the standard of care will be in a particular circumstance. So what we'll need to appreciate is what duty is owed to which particular type of individual entering into the property. There are defenses to occupier's liability, and one of the main ones is voluntary assumption of risk. So if the occupier has a duty to take reasonable care to ensure that the property is made safe, but that doesn't apply if the person has voluntarily assumed the risk of engaging in that or coming onto the property. They've entered at their own risk, you might say. In the case of exclusion and of liability, that is also a way of defending a occupier's liability lawsuit. And lastly, an individual may be contributory negligent. They may have worn the inappropriate footwear, for example, that they were, and slipped and fell on the property, and therefore are partially responsible, contributory negligent for their own losses. The tort of nuisance occurs to address those conflicts between neighbors and that stem from their use of the land. Nuisance occurs where there's an activity by the occupier which unreasonably and substantially interferes with the neighbor's right to quietly enjoy his or her property. But it's not something which is sort of temporary. It has to be a sustained activity, in fact, to rise to the level of nuisance. So it has to be, the intrusion has to be significant and unreasonable, and it can't necessarily just be temporary. There are some exclusions. You cannot There's no right to sunlight, for example, so that's not regarded as a nuisance claim. And what is important about nuisance is that there's a balance between protecting the landowner's quiet enjoyment and economic activity and the effects of that as well. The tort of trespass occurs where there's been some wrongful interference on the property of another. So if you come onto the person's property without their express or implied consent, or if you were initially invited into the property and you remained past the date or the time you were expected to be there. So for example, you are now, if you were in class, you are contractual entrance, but if you stay past a certain time, you become a trespasser. So your class, your visitor class will change, and therefore the standard of care owed by the university to you will also change as well. If you are to leave an object on property without permission of the owner, that's also regarded as trespass as well. So we're using trespass to resolve boundary disputes and title disputes, in fact. And normally you're using an injunction, which is an equitable remedy, to prevent an individual coming onto your land. Now, with trespass, it's a slightly different tort, because normally with torts you have to show that you've had a loss or you've experienced damages. With trespass, it's not the case because the fact that you have had your quiet enjoyment violated is the loss that you've incurred. So even though you've not incurred any financial losses, you can still claim trespass, the tort of trespass. Let's look at next, in the second part, torts that arise from business operations. This can occur, let's say, for example, if you're a bar owner and you have a bouncer that roughs up customer. This can occur concurrently, so you threaten and then you physically harm that individual. Then the employer, the bar owner, can be vicariously liable for that particular tort. The tort of false imprisonment commonly occurs in the retail setting where there's been a physical restraint on an individual or they've been threatened injury, so they are prevented from leaving. It is referred to as false imprisonment if the claim is not justified. Now you can defend this you can defend yourself against this if you're the shop owner if you have a lawful justification, that is to say you're making a citizen arrest. You must have reasonable grounds to do this, of course, and there must be the proof of crime or proof of fraud being committed. Also important that if you are defending yourself against false imprisonment, that you must immediately call the police in order to avail of this particular defense. Here I present two bags from the luxury bag manufacturer Louis Vuitton. One is a fake, and you can decide for yourself which one it is. You can notice one bag has a different type of logo, a different type of handle, and then the courts now have to determine what actionable wrong has occurred here. The way this is done is through the tort of passing off. So it's presenting the goods or services of somebody else, another company, as your own. In order to demonstrate passing off, you've got to show that there is some goodwill attached to the look or the product, that there's been some deception or public misrepresentation that sows the seeds of confusion in the minds of the public. And lastly, you've got to show that there's been actual or potential damages as a result of this. So, the piracy or the counterfeit merchandise is an enormous loss for luxury manufacturers, and occurs quite a lot, in fact. And this is formally referred to as passing off. The tort of interference with contractual relations is that circumstance where you incite somebody to breach their existing contractual obligations. So, for example, if you poach an employee from another company, you induce it cause them to breach their contract. You can be sued by the company that you've caused that employee to leave for inducing that breach of contract. Now, you don't necessarily have to force the person to continue working for you. That is to say, you don't have you don't have the possibility of specific employment performance, but you can prevent that employee from working for the other company. That is possible, and that's referred to as injunctive relief. The tort of defamation is another form of tort, which is the public utterance of a false statement or, of fact or opinion that harms the reputation of another. In the written form, this is referred to as libel, and in the oral form, it's slander. So what you've got to show is that the defendant's words lowers the reputation of the plaintiff in the eyes of a reasonable person. This is one of the torts that has to occur to a living person. It must refer to the plaintiff, the person who's suing, and it has to be communicated to at least another person other than the plaintiff. There are a number of defenses to an action in defamation. If truth is regarded as a defense to defamation, if the statements in fact are true, it's not defamatory in fact. If you have a qualified privilege, if you are speaking in the context of a court-based proceedings, that is not a place of suing in defamation, because the court wants to have a full airing of the views made by witnesses, for example. Fair comment are those circumstances where you are commenting on a public individual, and it's a matter of public interest, and it's something that is factually based. So a restaurant review, for example, if you thought that the food that you were reviewing, or the quality of the service was poor, and you write about that on the internet, that's not regarded as liable. Part of the reason for that, it's regarded as fair comment actually, because those views could be honestly held by anyone. If it's a matter of public interest, then the reporter, for example, has exercised all due diligence in determining the veracity or verified their sources, that is also regarded as a defense to defamation also. And lastly, there is a defense of absolute privilege. So in the context of parliamentary proceedings, you are not able to sue in defamation because of that particular forum. So what I'd like you to do for next class is look at this problem question. What you'll be doing is identifying the issue, the relevant law, applying that law, and coming up with a conclusion in this particular case, and advising EP Taylor Bar. That's it for this session. Thanks very much.